Join me on Mondays from 9 to 11 p.m. on WNN for The Michael Blum Show, where we talk about the things you don't want to talk about. We talk about sex, substance abuse, spirituality, and politics. Think, speak, and be heard. Join us on The Michael Blum Show.
If you suffer from excruciating back pain and sciatica, pay careful attention. According to a study in the medical journal Spine, back surgeries to alleviate pain frequently backfire, leaving patients in more pain than before the surgery. A second study from the University of Cincinnati's College of Medicine provides clear evidence that 74% of surgeries for the back fail. But there is a solution and an end to your suffering. Dr. Fernando Ranella, he's a medical doctor and the founder of the Center for Back Pain Management, where he specializes in the elimination of back pain and sciatica quickly, easily, without surgery or any pain medication whatsoever. Dr. Ranella accepts Medicare and most insurance. He has a location in Delray and one in Fort Lauderdale. Call 561-819-6325. That's 561-819-6325.
What you want to know. What you need to know. Talk 1470. WNN.
The opinions expressed on the preceding sponsored program were strictly those of its hosts, guests, and callers, and not necessarily those of this station, its staff, management, or sponsors. The content of the following program, including all statements from the host and guests, is to provide general information and commentary about the law. Under no circumstances does any statement made by a host or guest to a caller or listener constitute legal advice or the formation of an attorney-client relationship, and the material from this program should not be viewed as a substitute for personal consultation with an attorney. Welcome to Talk Legal with Jeff Van Treese, who brings you all the latest news in the legal world. Jeff will be discussing a variety of legal topics with experts in the field. If you would like to ask a question or share a story on the air, please call toll-free 888-565-1470. Once again, that's 888-565-1470. Now, let's talk legal with Jeff Van Treese.
Good evening and welcome to another edition of Talk Legal. I'm your host, Jeff Van Treese. I'm an attorney with the law firm Oltman, Flynn & Kubler, where we practice intellectual property law, including patents, trademarks, and copyrights. You can check us out online and view all episodes of this show on our website at oltmanpatent.com. That's oltmanpatent.com. I would also like to thank all of our listeners, including those of you tuning in on the AM dial, as well as those watching online. If you have a question, comment, or story that you'd like to share on the air, please feel free to call us toll-free at 888-565-1470. Once again, that toll-free number is 888-565-1470. We welcome your calls. I have a very special guest in studio this evening. His name is Gus Bravo. Gus hosts his own legal talk show on Monday evenings at 6 o'clock. It's called Attorney Confidential with Gus and Neil, starring Gus as well as his co-host, Neil Codsey. And this past Monday was their third week on the air. The show's going very well. And Gus is joining us this evening to discuss the consumer protection laws, specifically the Fair Debt Collection Act and the Fair Debt Reporting Act. Gus is a general litigation attorney. He's a consumer advocate, and I'm very fortunate to have him on the show this evening. So, Gus, thank you so much, and welcome to Talk Legal.
Thank you. Glad to be here. I really enjoyed the introduction, especially when you said starring and then said Neil is co-hosting, which I like. Putting me a little bit ahead of Neil. But glad to be here.
Well, I do appreciate you coming on. I know Neil's been on the show a couple times, so I'm glad to finally have Gus on the show. So tonight we're going to talk a little bit about some consumer protection laws, the Fair Debt Collection Act and the Fair Debt Reporting Act. These provide protections to consumers from abusive practices from creditors. However, we've all heard of it, but what are some of the main issues that come up with respect to consumer protection?
Right. Well, I think, first of all, let's start with the acts. There are three separate main consumer protection acts. The first one, as you mentioned, it's the Fair Debt Collection Practices Act. The second one would be the Fair Credit Reporting Act. And the third is the Telephone Consumer Protection Act. those three have some overlapping principles, but they're meant to protect consumers at different intervals of, I guess, their relationship with creditors, with debt collectors, and telephone marketers.
So when a client comes to you, they may have been harassed, they may have been called on their cell phone, they may have been called at home at times that are really not appropriate. So when you're assessing a case, what are some of the common things that you're looking for to see whether a client might have an action under one of these acts?
Okay. First, we find out who's calling them, right? I mean, I think that's the most important thing. Who's calling you? Is it a debt collector? Is it a creditor? They're not necessarily the same thing. A debt collector is someone who's usually hired by a creditor to collect the debt. It doesn't have to be a debt it could be a current debt that you just fallen behind on payments. So for instance, you have a mortgage payment that you haven't paid. If your bank, for example, Wachovia calls you, they're not a debt collector, they're actually just a creditor contacting you about a past due debt. However, if Wachovia hires somebody else to collect that debt on their behalf, then that third party is a debt collector. And so they would be subject to the Fair Debt Collection Practices Act. Whereas Wachovia would be subject to the Telephone Consumer Protection Act and maybe Fair Credit Reporting Act. It depends. So first we have to identify who's calling you, number one.
Right.
The second thing would be, what are they calling you about? Is it an existing debt? Is it to market services? Those are two critical distinctions. If you owe money and they're calling you on a debt, there's certain rules and regulations that apply. But if they're just calling you to offer their services, then a whole other area of the laws will trigger.
So, one of the things that a debt collector is required to do is they're required to identify themselves at the beginning of
Correct.
the call as a debt collector. They have to say that this is a debt collection agency and that anything that you, the consumer, say can and will be used for the purpose for debt collection. It's sort of like a Miranda warning.
Yeah, I think we all love those repetitive things, but they're doing it because obviously they have to comply with the law, and the law requires them to identify themselves. And actually, they have to identify themselves first before they ask you to identify yourself. Even though they're the ones calling you, sometimes clients come in and they'll tell us that the debt collector was asking for their information before they actually identified who they are and who they work for and what are they calling about.
Now, one of the interesting things that I've always thought about with debt collection is, usually if somebody owes you money, you can go to an attorney, they can file a lawsuit, but debt collectors are generally not attorneys. They're just these third-party agencies that,
right,
for all intents and purposes, their job is to harass you into paying their client.
and but they can be attorneys. There are some law firms who exclusively that's all they do is they collect on debt. Sometimes they'll even buy the debts. I'm not going to name names, but I've been on the other side of the coin defending individuals who are being sued by law firms who are actually debt collectors. And in fact, in the stuff that they file, the pleadings that they file in court, and certainly the letters that they exchange, even with the lawyers, with us, they put the little disclaimer at the bottom. A debt collector can pretty much be anyone. Think about a hired gun, right? Anyone who's hired by a creditor to collect that debt. There was one example, I think I recall a case out of Pennsylvania where a hospital you had a fictitious name that they use to collect on their debt. So it was a hospital, let's call them Hospital X. And they decided to create a separate fictitious company. By that I mean it was not a real company. They just created a separate name as their collection agency. And so in that case, the court determined they were a debt collector. Even though they were obviously a function under a fictitious name, they were still a debt collector. So it could pretty much be anyone who's a hired gun who's acting on behalf of a creditor.
So, they have certain restrictions on debt collectors, and if they violate those restrictions, then the consumer might have a cause of action or claim against the debt collector,
Yes.
even if there's a debt owing. One of those is the time that the phone call is made to the consumer.
Right.
If it's made before 8 a.m. or after 8 p.m., that's a violation. That's grounds for a lawsuit. And in the event that there is a violation, also if they're on a do not call list and they call them anyway, that can be a violation. they're pretty serious sanctions. It can be $500 for each phone call, and if this is done on a mass scale, this could potentially be a lot of money.
Absolutely. So in your example was excellent because in your example there were violations of several different statutes or acts. So you have a telephone consumer protection violation, then you have the fair debt credit or fair debt collection violation. So the example of not calling before 8 a.m. or after 9 p.m. could actually apply for multiple of those acts. Certainly, the calling you and without your prior express consent trying to sell you something, that would be what we consider a telephone consumer protection violation. So I think we've all gotten at some point those texts. For instance, we buy junk cars. I don't know if you ever experienced that, but I remember getting those about a couple years ago, just unsolicited text messages. Well, that's a violation of the law. And in those examples, rest assured you're not the only person that got that. There were thousands and thousands of people that on a mass scale got that unsolicited text or call. And then the key in that is if that unsolicited text or call was generated by what's called an auto dialing system, which is basically a fancy way of saying, look, the telemarketer had some computer that they just automatically dialed the numbers for them. It's not like the old days where they're in a smoke-filled room where they were just punching the numbers, but actually a computer system that dialed it. That's a violation of the TCPA, the Telephone Consumer Protection Act, which could be either $500 for a negligent violation or $1,500 for intentional or willful. And in those cases, those are perfect for class actions. There have been some big name companies that have had to pay millions and millions of dollars in class actions for sending out these unsolicited marketing.
So, even if you owe money or even if you're unable to pay your debt, you still might have a cause of action where you're going to be in a bargaining position where, essentially if you're in a settlement conference, you could say, not only are you going to forgive my debt entirely, but you're going to be paying for my kid's college education.
Yeah, I mean, look, legally speaking, the violation of one of these acts does not forgive your debt. Okay, so it's one doesn't necessarily have to do with the other, but your point is actually well taken. If someone's going to hand you a check for $15,000 and you owe them $2,000, obviously it doesn't take a rocket scientist to figure out that you can negotiate on that debt or even just write them a check. And certainly in the TCPA world, when we're talking about class action settlements, those numbers are going to be significantly higher. But I think the takeaway, the initial takeaway I would have, whether it's fair credit reporting or fair debt collection or TCPA, these are consumer protection laws that are meant to stop harassment, that are meant to stop unsolicited marketing, and not only meant to stop it, but allow you, the consumer, to go on the offensive and get some money in return.
And this is a case where even if you don't think you can afford an attorney, you might not necessarily have to pay an attorney out at the initial onset of the litigation. In fact, most attorneys would take this on a contingency fee basis, right?
Correct. The Fair Credit Reporting and Fair Debt Collection Practices Act, both those have what we call an attorney's fees provision. That means if you file a lawsuit or if an attorney files a lawsuit on your behalf and he or she recovers money for you, not only are they going to get money from the other side, but the other side, the creditor or the debt collector, whichever may apply, will have to pay your legal fees. So in those instances, most lawyers will take that on a true contingency, which means they will not charge you any attorney's fees up front. They're just collected from the other side, and obviously will front the cost, which they recover from the other side. In the TCPA scenario, that act does not give the lawyers the ability or the consumer the ability to get their attorney's fees paid by the offending creditor or debt collector. However, because those violations can be significant and can get to the class action type of arena, obviously the lawyers are going to be able to recover more than their fair share from the other side. So even though technically you can't recover attorney's fees, because the numbers are going to be so high that the lawyers will gladly take those cases also on a contingency.
So I guess the moral of the story is you should be aware of your rights because in this case the law may very well be on your side.
Absolutely.
So we're going to have to take a short break. We're going to hear from our sponsors, and then we'll be back with Gus Bravo. Stay tuned.
This program is brought to you by Fresh Start Tax. Fresh Start Tax offers a full range of tax and accounting services, including tax return preparation and bookkeeping, as well as back taxes, wage garnishments, unfiled returns, or any other tax-related concern. Our dedicated team of tax attorneys, CPAs, and former IRS agents offer over 60 years of professional tax experience. For a free consultation, call 866-700-1040. That's 866-700-1040. You can also visit us on the web at freshstarttax.com. This program is brought to you by the law firm of Altman, Flynn, and Kugler. We practice elder law and intellectual property, including patents, trademarks, and copyrights. If you would like to patent your idea, please contact our Fort Lauderdale office for a free consultation. Call 954-563-4814. That's 954-563-4814. Or visit us online at altmanpatent.com. That's OLTMANPATENT.com. Spokesperson, not an attorney. You're listening to Talk Legal with Jeff Van Treese, who brings you all the latest news in the legal world. If you would like to ask a question or share a story on the air, please call toll-free 888-565-1470. Once again, that's 888-565-1470. Now, back to Talk Legal with Jeff Van Treese.
And we're back. My guest this evening is attorney Gus Bravo. We've been discussing consumer protection laws and fair debt collection. Gus is a general litigation attorney, and he's also the host of Attorney Confidential with Gus and Neil, Monday nights at 6 o'clock here on NN. So I'd like to turn our discussion to the reporting of debt to credit agencies. What is necessary for a debt collector or for a creditor to report a debt to a collection agency? Do they have to have a judgment from a court, or can they just report it as soon as, in their minds, the debtor is in default?
No, they don't have to have a judgment. It just could be you're late on payments. It's typically there's the standard, what I've seen in the industry, if you're past due 45 to 60 days, then it will get reported. I think most creditors will give you the 30-day window. If you're late 30 days, they won't report it. You know, what's interesting to note is that there's no requirement, however, that the creditors actually report anything to the credit agencies. The law is simply about what requirements exist if they choose to report it, but there's nothing that requires them to do so. So some of you may experience where you're late on your payments, whether maybe 2 or 3 months, and it just happens to be with a creditor that chooses not to report it. Whereas other creditors, the minute that you're late on the 30-day period, they will automatically report it. So it really depends on the creditor.
Now, what if you write a letter to the creditor or to the debt collector saying that the debt is in dispute for whatever reason? You believe that you were given defective products, or the goods were not delivered in merchantable condition, or whatever the case may be. If you are disputing the debt and they are given notice that you're disputing the debt, can they report it anyway?
Well, they run a huge risk at that point because if you've given them notice that they're disputing the debt, or that you're disputing the debt, and they go ahead and report it, then at that point, if it's found that reporting was inaccurate or the debt was not actually owed, then they're now falling into the willful arena of the intentional. They went ahead and reported even though they knew or should have known that debt was not owed. Usually what will happen is if you send that kind of writing to a creditor, they are required within a certain time frame to verify the accuracy of the debt. We're now jumping back to some of the collection practice stuff. Now, we're talking about Fair Credit Reporting Act. Once that debt appears on your credit report, you then have an opportunity, if you choose to actually communicate directly with the 3 main credit bureaus. And each of them has a system where you can actually dispute a debt, and they will turn around and conduct what's called a reinvestigation. The reason they call it reinvestigation because there's a presumption that when the debt was initially reported that there was some type of investigation, but
There often is not, right?
Often is not. And so the credit bureau will then, or bureaus will then send out a notice to the credit company or creditor who reported it and require them to verify the debt. That usually has to happen within the 30-day window, at which point the creditor will either, the credit bureau will then decide and respond to you by verifying the debt, modifying it, or removing it altogether. So I think it's a good practice for consumers if you feel that there's something on your credit report that's inaccurate.
I had a client one time that I helped write a letter for. She had carpet installed from a big box store.
Right.
And after the carpet was installed, there were staples that were sticking out of the carpet. And in fact, some people had impaled their feet on the staples. It was a very hazardous, dangerous condition. I actually wrote a letter to the big box store saying, come fix the problem. They sent out an adjuster. They said there's nothing wrong, even though they were shown the staples that had been removed from the carpeting.
Wow.
And they said there's nothing wrong and refused to fix the problem and sent it to a debt collector when my client refused to pay for the defective product. And I wrote a letter to the debt collector saying the debt is in dispute, you're prohibited from reporting this, and they dropped the account. They sent me a letter back saying we no longer have this account. About a year later, the big box store sent it to another debt collector and basically had to do the same thing again. The client ended up passing away, so it became a non-issue. But that just sort of illustrates the sort of gall that some of these creditors have, that they can sell a defective product and be perfectly comfortable in not fixing it because most people don't know their rights.
Yeah, you're absolutely right. It's the gall that not only the creditors, but also the hired guns, the debt collectors that they choose to associate themselves with. That also a lot of times take it even worse. You have to understand these companies, these debt collectors, more often than not, are actually taking a cut of whatever it is they're able to recover. So they're incentivized to try to get money from you, regardless of what type of approach they take. I think your scenario illustrates an example where, unfortunately, you kind of have to deal with it on a periodic basis. What we tell consumers is, look, make sure you have the right to get one free credit report per every 12 months, every year. Check your credit report, check it religiously as often as you can, and stay on top of any kind of inaccuracies. I think you're in your example, the fact that you wrote a letter put a stop to the collection practices, and then hopefully put a stop also to the reporting practices, which are two different things. Collection is mostly harassment, which none of us want to deal with, but that gets to a certain level. Reporting is something that's, I would argue, more important because that gets to your actual credit score and affects your credit. As we all know, we're all consumers. Credit score is incredibly important as far as trying to do business, getting loans, etc. So staying on top of your credit report is just as important as avoiding some of these harassing calls.
So who can see your credit report? Is it just you and other creditors? Can employers see it? Who's in a position to see what's on your credit report?
That's a good question. Well, it starts with the folks that you would imagine, banks, anyone that you applied for credit. You're given them permission to actually use you've given them your Social Security number, so you've given the consent to review it. Employers, I think, presents an interesting example. In theory, they're allowed to review your credit report, but they have to have your consent. So employers cannot look up your credit report without your consent. There's obviously, we hear every now and then stories of employers trying to run they have your Social Security number. Just because you've given them your Social Security number does not mean you've given them the right to look at your credit history or your credit report. And that's important. Just because they have that information, they should not be allowed to look at your credit history.
Now, if somebody's, let's say, is incapacitated, which happens a lot for medical bills. If somebody is in the emergency room, they may not even have capacity for the underlying contract itself.
Right.
And then they get a bill that's, through the roof. They had no ability, certainly, to negotiate it because they were they were not mentally of sound mind at the time that the services were rendered. Are there any special protections under those circumstances where you might have an incapacitated consumer?
Yeah, I mean, certainly lacking capacity, whether initially to enter the contract or then later on to fight or dispute the debt, is a defense that you'll be able to raise. I would recommend to folks that there's a lot of information that's available on these types of issues, capacity, military, for instance. The federal government has a great website. I'll spell it out for folks. It's consumer.ftc.gov, and it gives you a lot of information on the steps you can take in order to protect yourself. As far as the capacity issue, yes, it would certainly be a defense, could be a defense to it. Hopefully, the way things should work is that someone will be able to speak on your behalf, whether it's a next of kin or someone who's got a power of attorney to be able to dispute that. But from a practical standpoint, if you're lacking capacity to be able to fight your credit report, the next step for the credit agencies and collectors would be to file a lawsuit against you. And so if you lack the capacity to obviously be able to challenge something, you're also going to lack the capacity to defend yourself in court. So there may be some standing issues there. They get a little bit more complicated, and certainly the next 5 minutes something that I can explain. But I would want to share one story before we close, and I think this is important as to sort of the whole genesis and the background behind some of these consumer protection laws. The Fair Credit Reporting Act was passed in 1970, and one of the reasons it was passed was because apparently in the olden days, and I would tease Neil about this, back when he was growing up, I would say, in the olden days, the credit companies would actually send out women as a welcoming party to your house. So let's say, Jeff, you just moved into the neighborhood, or let's say you applied for a car loan. Well, you would get a knock on their door. There would be one or two women there with a cake, presumably, and saying, "Welcome to the neighborhood." And they would walk in, and they would literally sit down and talk to you and find out all sorts of information about you, race, religion, whether you drink too much, etc., what kind of job you have, and all those things would actually go into your credit report. And so needless to say, none of us would like to have that kind of information, or creditors making decisions about whether to extend credit based on that information. So the takeaway, I would say, that a lot of these laws that we're talking about are meant to make it an even playing field, give consumers the ability to protect themselves, and also, if the laws are violated, to go on the offensive and not have to come out of pocket and be able to get an attorney and maybe be able to recover some money.
Well, I think we're running out of time. We have about a minute or so left. Gus, if you could tell our listeners how you can be reached in the event that they're in need of your services.
Yes, absolutely. My website is lawbravo.com. Lawbravo.com. I'm happy to answer any questions you may have, and again, I appreciate you having me here as a guest speaker.
And in the few minutes we have left, or a few seconds we have left, just like to say, please tune in next week, Tuesday at 6 o'clock, where my guest will be Jeff Molinaro, attorney, and we'll be discussing the recent cheating scandal with the Atlanta school teachers. Gus, if you could just tell us a little bit about your show and when you'll be on next.
Attorney Confidential, starring Gus and lesser role Neil Kotze, Mondays 6 to 6:30 p.m.
Thank you so much, Gus. I'd like to give a special thanks to my guests. Tune in next week. This has been Talk Legal. I'm your host, Jeff Van Treese. Thank you so much, and have a great evening.
Thank you for listening to Talk Legal with Jeff Van Treese. Tune in next week for more insightful and exciting information about the law. You can contact Jeff by email at jvt2law@gmail.com or give him a call at 561-789-6866. That's 561-789-6866. The content of the preceding program, including all statements from the host and guests, is to provide general information and commentary about the law. Under no circumstances does any statement made by a host or guest to a caller or listener constitute legal advice or the formation of an attorney-client relationship, and the material of this program should not be viewed as a substitute for personal consultation with an attorney. The opinions expressed on the preceding sponsored program were strictly